Good morning. I am Councilmember Zachary Parker, Chair of the Committee on Youth Affairs. Today is May 14th, 2025. We are meeting in room 412 of the John A. Wilson Building. And we are also entertaining guests virtually via Zoom. The time is now 10:08 a.m. and I am calling to order this public roundtable. I want to thank my colleagues who will join. I am told we will be joined by Councilmember Pinto for a portion of today's hearing. Today, we are convened to hear testimony and discuss two timely topics under the purview of this committee. First, we will review the findings of a report released by the Office of Independent Juvenile Justice Facilities Oversight titled Inspection, Testing, and Maintenance of Fire and Life Safety Systems at the Youth Services Center and New Beginnings Youth Development Center. The report focuses on the fire and life safety systems at DYRS's two secure facilities, YSC and New Beginnings, between September 2020 and November 2023, with select updates through 2024. A copy of the report is posted on our HMS Council hearing portal. My committee staff and I made an unannounced visit to YSC on Monday of this week to inspect conditions at the facility. We are continuing to see how things are operating at both YSC and New Beginnings, and I shared a reflection publicly that I continue to be alarmed at the lack of services provided to young people at YSC, but also the lack of quality in education programming at the facility. While today we won't delve as deeply in those two subject areas, that is remaining top of mind for me. We also investigated, based on this report, whether or not certain conditions were in place. And I imagine we will talk about that today with Mark Jordan. We were expecting DYRS Director Sam Abed to join us for today's roundtable, but unfortunately we're told that he could not make it at the last minute. We will reschedule today's roundtable so that we can hear from him at a later date. I think it is important to get the agency on the record in response to what we hear from Mark Jordan. We know the issues with DYRS's fire safety systems are not new. They go back over 2 decades. And while much progress has been made, as the report details, the latest findings demonstrate unacceptable conditions that warrant immediate attention. As the report talks about, there is increased concern when you have secure facilities where an individual cannot, at their own will, escape the building in case of a fire. And that is why today's hearing is important and timely. To be clear, these are not issues that can wait on budget negotiations. The safety of our youth and staff depend on it, and we have a responsibility to ensure DYRS is in full compliance with safety regulations in a timely manner. And so after today's hearing, not only will we schedule that conversation with the director, we will be talking about and following monthly on the agency's compliance with the findings of the report. Today, we will also discuss Bill 26-0186, the Justice Involved Youth and Community Act of 2025, which seeks to establish a program to provide a trusted adult to offer intensive wraparound support to participating youth with a deferred disposition agreement, deferred prosecution agreement, or consent decree for the length of the agreement. The bill's hearing was held by the Committee on the Judiciary and Public Safety on April 23rd, 2025. We will not seek to rehash the hearing and the comments made then. Instead, the focus of today will be to hear more from advocates, dig deeper, and inform comment that will be produced from this committee and shared with the Committee on the Judiciary and Public Safety prior to the bill's markup. We were hoping that the Office of the Attorney General would join us today to share formally, but they had a scheduling conflict and could not join us. They have committed to writing in a formal response to a series of questions ahead of us making those comments to the Committee on the Judiciary and Public Safety, and we look forward to receiving those comments. Our goal will be to provide this committee's perspective on the bill and gather input on the need for any amendments that should be proposed. Our conversations with youth make it clear that investments in mentorship and supports are needed to help guide them on the right path and navigate finding better opportunities for their futures. I was struck this week when I was at YSC, one of the young men that I spoke to, I asked, what would have prevented you from being here? And his response was mentorship or having a big brother. Nevertheless, we must strike the right balance to ensure we are meeting families and youth where they are and providing effective, evidence-based supports that target their biggest needs. There are several advocates and stakeholders here today who will voice their perspectives on the legislation, and we thank them in advance for joining and look forward to hearing their comments. Our office is working closely, as I mentioned, with the Office of the Attorney General to ensure that the implementation of this bill, should it be passed and enacted, will not interfere with the functions of that office and the very important work that they do. So with that, we will first hear from Mark Jordan, the Executive Director of the Office of the Independent Juvenile Justice Facilities Oversight. He will detail the work that he and his team and a number of consultants did to investigate the safety conditions at YIC and New Beginnings as it relates to fire code and expectations. I will have a number of questions for him, and then we will transition to the rest of our guests, who I am understanding are here to testify regarding the bill, Bill 26-0186. So with that, Mr. Jordan, it's good to see you again. You joined me Monday for that unannounced visit to YIC, and I appreciate you for taking time to do that. I'm going to turn it over to you to make a statement, and then following that, I will have a number of questions for you.
Good morning, Chairman Parker and members of the committee. My name is Mark Jordan, and I am the Executive Director of the OIJJFO. I appreciate the opportunity to testify before you today at this roundtable about the report my office released in March regarding fire safety issues at the YSC and New Beginnings. In any building, including the one that we're in right now, functioning fire and life safety systems are essential to mitigate risks to life and property. But in locked facilities, like the YSC and New Beginnings, functioning fire and life safety systems that can detect, communicate, and suppress fires are even more critical because, by design, building occupants are not permitted to evacuate themselves without assistance. The March report focuses on one of the pillars of an effective fire safety program: routine inspection, testing, and maintenance, which I'll refer to as ITM, of the systems that detect, suppress, and prevent the spread of fires and smoke within a facility. These systems include fire detection and reporting systems, commonly known as fire alarms, water-based suppression systems, which are sprinkler systems, portable fire extinguishers, emergency power generators, HVAC systems, electric and remote locking systems, and extinguishing systems in kitchens, which present their own heightened fire safety risks. Unlike many building systems, such as indoor plumbing, which is tested multiple times per day as occupants use sinks, showers, and toilets, fire safety systems are not used routinely. Thus, they must be tested and maintained according to established industry standards to ensure that they will be operational in an emergency when they are needed. The March report details a 20-year history of DYRS closing Oak Hill, an obsolete building with few fire safety systems and virtually no operating fire safety policies, to opening its 2 existing facilities and creating, through fits and starts, a previously non-existent fire safety program. I will not recount those details here, other than to say that by 2020, the then court-appointed special arbiter found that DYRS had, quote, established contracts for appropriate inspection, testing, and maintenance of the fire prevention systems and equipment at the YSC and New Beginnings, while also noting that there were several areas requiring further action. Importantly, however, the special arbiter cautioned that, quote, in light of the historic concerns regarding the adequacy of the contractual service procured by DYRS in the area of fire safety, these inspection, testing, and maintenance services will require ongoing review and scrutiny, close quote. In fact, the March assessment validates this warning, documenting significant backsliding in DYRS's fire safety program over the subsequent 5 years. The report establishes that between 2020 and 2024, mid-2024, DYRS maintained ITM contracts that were consistent with relevant testing standards. However, there were significant limitations in the testing that was conducted. In some cases, testing documentation did not establish whether ITM was complete and consistent with applicable testing standards. In other cases, serious problems identified during testing went uncorrected for months. In an extreme example, repeated monthly testing documented that the fire alarm system at the YSC was, quote, condemned, with no explanation of the significance of the finding and no remedial action taken by the agency. The report documents that in mid-2024, contractual services for ITM ceased altogether at the YSC in New Beginnings, and that no fire safety inspections were conducted through the end of February 2025. As of last week, there were still no contracts in place for the testing of the water-based fire suppression systems, portable fire extinguishers, emergency generators, HVAC systems, and extinguishing systems for the range, hood, and duct, all of which were overdue for testing. While a contract is now in place for the testing of the fire alarm systems at the YSC in New Beginnings, a recent March test of the YSC fire alarm system found that the system was non-operational. Consequently, the DC Fire Marshal required the facility to implement an around-the-clock fire watch using YDR staff to identify and report fires, a requirement that remains in effect. Nevertheless, during a site visit this week with you, Councilmember, I did not see evidence of the fire watch being implemented as required. The YSC fire alarm system, which was installed in 2004, is no longer supported by the manufacturer. It is due for replacement, but I'm told that there is no funding for the project. DYRS spent decades building a program to inspect, test, and maintain critical life safety systems in their locked facilities. In recent years, and particularly since mid-2024, that program has all but collapsed in apparent disregard. With sufficient resources and focus, DYRS can rebuild the ITM infrastructure they worked so hard to create. I recognize that fire safety issues are not directly relevant to youth development and programming that are central to DYRS' mission of rehabilitating youth in its custody. However, functional fire safety systems are a basic building block of creating a safe environment for youth and staff alike. I appreciate your taking the time to focus on this issue and to consider its significance in the broader context of the environment and culture DYRS is creating at the YSC in New Beginnings. And I would be happy to answer any questions you may have about the report.
Thank you. At the outset, I would love to level set for those that may be watching. In your opinion, why is this topic so important?
Fires in facilities should not be, and have not been, high frequency events, but they are high consequence events. If you have a fire in a facility, in a locked facility, and people cannot evacuate themselves, there is a history. The regulations on testing and standards were based on histories where multiple people died in fires in locked buildings. And that's why it's so important. I would say that the YSC and New Beginnings are very different facilities, and the YSC presents particular and higher risks than New Beginnings. But it's critical to make sure that the systems are in place to detect and prevent fires and to respond to fires. It's not just fire that can cause loss of life. Smoke can cause just as many or more. Smoke inhalation is a significant cause of death in fire events.
And when we were at the facility at YSC this week, it is important to stress to people that navigate through YSC, there's someone in a control room that's controlling the doors. And so we literally were trapped in certain hallways or doorways until the door was open. And then part of that is for security reasons, obviously, which again speaks to what you're stressing, that in the instance of an emergency, one would not be able to escape YSC with their free will. And we're talking about the life of hundreds of individuals, many of them incarcerated youth, in a building where we don't have full confidence with fire safety and systems. So I just want to stress that is why this is so important, and it must be addressed immediately.
If I may add to that,
Yes.
You're absolutely correct. And there's something unique about the YSC, which I think is important. If there were a fire in this building right now, the reaction, everybody would evacuate to the outside. At the YSC, that's not the case. At the YSC, it's what's called a shelter-in-place facility, which means your first reaction should be to stay in the building. It's divided into sections that are called smoke compartments, intended to divide the building so that you can remain in the building safe from a fire. Because of that, there are a lot of policies and procedures that need to be in place so that there's effective communication about where a fire is, where the building occupants should go, or whether they should stay where they are to remain safe. So it's very complicated, that building in particular.
So at a high level, would you say that YSC and New Beginnings are safe given the current conditions of the ITM report that you produce?
One advantage that both facilities have is that they are staffed around the clock. That does not guarantee safety by any stretch. And in fact, I would say in March, after the YSC's fire alarm system was found to have failed, the DC fire marshal required the YSC to put in place what's called the fire watch. And that is specific staff members are required to be present to look for, identify fires and communicate those fires throughout the building. So I think that speaks to the fire department's level of concern. Ideally, it's been a long time since we've seen a fire event, but I think that the consequences are too high to avoid.
And on that point, to the fire watch, I know as we were going around the building, we were asking who is the individual or individuals that are responsible as the denoted fire watch leader. And it's my understanding those people are meant to be identified and they're supposed to have key roles in every part of the facility. What it seemed like was happening was that there was one person tapped per shift as the fire watch, and we never encountered that person. And why might that be insufficient based on what the fire marshal imposed following the March finding?
Part of the issue at the YSC is, for example, the control center is the area of the facility where staff have all of the cameras. They can see everything that's happening. They open the door when you walk through. They're the individuals who should have access to the fire panel. So if there's a fire, there is a fire panel in their area that should say there is a fire or an alarm, at least, in this part of the building. Based on that knowledge, can communicate throughout the building where people should go or whether they should stay. One of the problems with the system right now is that fire panel in control is not working, which means, and there are a lot of audible devices throughout the facility that are not working. So in the event of a fire, you need somebody who is in the control center who can identify where the fire is and can communicate throughout the building where people need to go. The control staff, there's always staff in the control center, but they're very busy. They're opening doors, they are answering phones, collecting information. They can't exclusively pay attention to fire, which is one of the reasons that the fire department says you need to have somebody dedicated in the control center to be this fire watch person until this alarm system is up and running.
And was there an individual in the control center when you stopped in the facility this week?
There was not. And the control center staff that I spoke to seemed confused by the notion that there would be a fire watch staff member assigned to the control center.
One of the other notes I made of your report was that although the independent consultants that ran the test of the systems said that there was a baseline functioning prior to March of the system, that many of the components were out of date. In other words, if it needed to be repaired, the parts may not exist. And so to me, what that says is it's a matter of time that there's a breakdown in the system and we can't repair it. And I'm going to get to your recommendations moving forward, but that also speaks to how old of a facility this is, now over 20 years. And while it may have met standards 20 years ago, it's clear that we are not currently meeting standards. I'm just, again, pointing this out for those that may be watching, that this is a critical matter of life and death and safety for the facility. I want to turn, can you pinpoint the specific changes that led to the reversal of decades of progress that have been made within DYRS in terms of fire safety? It seemed to me as I was reading that while under Jerry M., there was a concerted effort to meet expectations, and we did meet those expectations, namely about 10 years or so ago. But ever since coming out of that agreement, it seems like our due diligence has slipped. Is that fair? And what would you pinpoint as the turning point for a shift in our readiness?
The last assessment that was done was 2020, so just before the pandemic. And at that point, by and large, DYRS was doing an adequate job. There were documented deficiencies that were identified and were recommended to be improved. They were manageable problems. But what we've seen in this assessment of the time period since 2020, I think part of it is a lack of diligence. There were recommendations that were made that were simply not implemented. Testing that was done that identified problems, those problems were not remediated by the agency. And that's more a question of just diligence in following up, taking a problem, reviewing the documentation, ensuring that it is quickly resolved. And we did in our report track a number of deficiencies to see how long, if and how long, it took to remedy problems in various areas, generator testing, sprinkler systems. And what we saw was that there were even when there were clear and serious problems identified, it took a very long time. That's about diligence. I think the other problem since mid 2024 has been a funding issue. Contracts have not been extended. And I suppose there has just not been enough of a priority put on fire safety, and that's a different problem.
That's right. And that's why we're having this conversation. We know often what gets measured gets focused on because there's a spotlight on it. And again, I suspect because this hasn't been top of mind or a focus or highlighted, there are any number of other priorities that have taken the forefront. We have heard in prior hearings that within the council that DGS believes they only have partial responsibility when it comes to DYRS facilities. In your view and in your history of working with the agency, is it your opinion that DGS has responsibility for DYRS facilities?
I think that's up to the executive branch to figure out who they're going to make responsible.
Well, let me ask it this way. As you have engaged not only in producing this report, but working with the agency's leadership, where have they looked to improve the systems at DYRS facilities or replace malfunctioning alarms and fire extinguishers? Have they gone to DGS or have they looked for independent contractors?
They are reliant on DGS, and where they are right now is by and large, when they need a new alarm system, when they need generators fixed, they go through DGS. There was a time in the history of JRM when DYRS initiated its own contracts directly rather than going through another agency, because testing in locked facilities, all of the testing standards are established by what's called the National Fire Protection Agency, NFPA. They are adopted in the DC municipal regulations and in building codes. It's simply, we have seen examples, the quality of testing is not necessarily of equal quality between vendors. We, in the history of JRM, saw testing vendors that did inadequate jobs, and we've seen testing vendors that did excellent jobs. Even over the course of this review, we saw examples where the testing standards that were used were not clear, the tests that were conducted were not clear, the number of devices tested were not clear. And that's a quality issue that needs to be addressed, and it needs to be addressed by whoever holds the contract. So I would say DYRS right now relies on DGS, and maybe they revisit that relationship and contract independently.
To that point, I was struck in the report where you said the term condemned was used to reflect on the malfunctioning nature of some of the panels in the control room, but that term condemned is not a usual term used within the industry as it relates to fire safety and code. I guess what I'm getting from that is whoever DGS contracted with, perhaps they were not aligned with industry standards, at least using common language as they produced the report. Is that fair?
It is a fair question. We had the same, when we reviewed the reports and saw condemned, we asked our own experts, and they said it's simply not a term that's used in the industry. And because of that, we had to organize a call with the testing vendor to try to establish whether or not the alarm system at the YSC was functional. And at the end of the conversations, we could not get a clear answer about whether or not in the event of a fire, the alarm system would detect and communicate it. And that's why we brought in our experts to test the system ourselves.
Understood. So to me, that says there needs to be a check and a balance, at least with certain contract negotiations with DGS. Where could we go as a committee to compare a contract that's coming from DGS as it relates to this topic? Like, are there standards that we can compare it to? Or I know you use your own independent contractor to kind of vet what the report was telling you, but what would you recommend for the committee? Where could we go to kind of vet what we're seeing in a contract that might come from DGS?
That's a good question. Excuse me. I will say that testing standards are highly technical. And that's the reason why in JRM, the district was required to outsource the testing because it is so technical. You cannot reasonably expect the agencies to have that capacity to test these systems. And I believe I would not be comfortable myself reviewing a contract. I would rely on an outside expert to do so. So for me, it would be relying on an outside expert to do so.
Understood. Okay, I will follow up on that, because what it makes me think is perhaps there needs to be a panel of experts that we at least consult to review contracts as it relates to safety matters, fire code matters, because I was alarmed by that. And what it suggests is, while, they may have run the tests, I'm not sure how reliable it is if experts within the industry are saying this terminology is not what we normally use. I'll leave it at that for now. I do want to go to the recommendations that are contained in the report, and I'll go through each one. And I would love to just have you elaborate and speak to what progress has been made, if any, by DYRS. I would love if the director was here to speak about this from his perspective, but again, we will follow up with the director when the time is allowed. So recommendation 1 is to ensure fire safety contracts are consistent with NFPA standards, and that they are put in place immediately and maintained without gaps between the contracts. So obviously the report spoke about a gap in the contracts that existed. There was a lapse in mid-2024, and there was no ITM performed for at least the last 7 months, while there were clear problems that existed. DYRS acknowledged the inconsistencies in fire contracts, and that DGS is actively working to secure those contracts to ensure compliance. Given what we just discussed, again, the committee will be working with DGS to vet and review those contracts, even if they fall under the statutory requirement for council review to ensure that they are in compliance. But what has been your take on what DYRS has done regarding this recommendation today?
Other than a contract, I think is a district contract. There was testing done on the fire alarm systems. Other than that, I believe there has been no more testing of the other systems yet. So I believe they're not in place.
Okay. Recommendation 2 was to maintain complete and accurate inventories of all fire safety equipment to ensure that ITM contractors perform complete testing. These inventories should include fire alarm devices, fire extinguisher devices, and fire dampers. In part, DYRS said they are in the process of creating a digital tracking system, and that they acknowledge that there is a need for this type of auditing in place. What has been your take about the agency's progress here?
I do not know whether they have finished that. The real proof will be at the next testing intervals. The origin of that recommendation is what we saw in consecutive tests were at time grossly different numbers of pieces of equipment that were tested. So the same fire alarm tested in sequential years might have very different number of alarms or strobe lights, speakers tested, which raises the question, is the testing complete? So it really gets to the
And
issue
is
of-
it reliable?
And is it reliable? Absolutely
Yes.
right. And I think that really having just a ground truth inventory of devices to make sure that you can check and be diligent about what was done, that the agency needs to make sure that the testing is complete.
And it's worth noting, DYRS said they will take actions on this recommendation by August 2025. So the committee is tracking and will follow up on that as we near August of this year. Recommendation 3 was to archive documentation of remediation efforts with the ITM documentation. The agency says they will take actions on this recommendation by August of 2025. Again, they reference a digital repository and that it will be created to help them act on this.
I think it's not ripe for us to review it yet. I don't think there's been the testing to identify those deficiencies. It would be very important. It was challenging at times for us to identify corrective actions, the deficiencies we could identify, and then trying to track it against any remedial actions that were taken was not simple. So this is designed to make that simple for anybody checking to see whether or not repairs have been made, so that it would all be stored together. This was the problem, this was the solution.
Recommendation 4 was to review and update fire safety inspection forms to ensure consistency with district adopted standards, which can change over time, and to eliminate any unnecessary information. And so this push was, we shouldn't be reliant on forms and standards set by an independent contractor, certainly if that contractor might not be reliable or is using terminology or assessments that may not meet industry standards. The agency said they will seek to meet this recommendation by September of this year. And that a review of all fire safety inspection forms is underway. And the new forms will eliminate outdated references to past NFPA additions, ensure all essential test results, device details, and standards used are documented, remove any irrelevant information, and that they will coordinate with contractors to standardize reporting formats. Any progress that you know of?
I'm not aware of that. We would not see that until the testing is actually done. The importance is that the NFPA, they update their standards over time. The district adopts a version of those, so there are NFPA versions every several years that will get updated. And the district doesn't necessarily adopt the most current standard, and that's not unusual. Sometimes there's a delay in adopting them because the building industry has to adapt to those as well. But what's important is that everybody's clear about which standard is being used, so that when a test result comes out, everybody knows what test was conducted. And so that's why it's essential that any forms say this was tested according to NFPA 72 2023 edition, so that it's clear.
Recommendation 5 was to ensure that the identified deficiencies are deemed to be critical life safety matters and treated as urgent matters for purposes of timely remediation. And I think this is really critical given that we are talking about a life and death topic here. The agency said that they would implement the following by May of this year, it is currently May. To address the delays and deficiency remediation, DYRS is implementing a rapid response categorization system for fire safety issues. The new contract with DC Fire Life Safety LLC requires the vendor to both inspect and remediate any deficiencies identified. I'm skipping through some of this. Non-critical issues will have designated timeframes based on risk assessment. DGS is collaborating with DYRS on maintenance and replacement of the generators at both facilities, and documentation of issues will be tracked in a central place. But what I'm hearing you say is that there's no known progress on this.
The only testing that we've seen is the fire alarm systems, and there were issues identified, some of which were addressed shortly after, but the system at the YSC remains inoperable. As far as I know, there is, I don't know the most current status of the replacement of the fire panel at the YSC, but funding has been an ongoing issue between DGS and DYRS. So that seems to me to be an urgent issue, and it's still not resolved.
Recommendation 6, install an NCC with a graphical user interface as part of the planned YSC fire alarm replacement. The consultants that you hired made a recommendation that DYRS should install this NCC interface, and control center staff are responsible for directing the movement of YSC building occupants as a shelter-in-place facility. Knowing the location of the fire is a precondition to coordinating a safe evacuation response. An NCC would communicate the location of a fire in the building much more readily than the current fire panel in the YSC. And it's worth noting that fire panel that is currently inoperable in the command center, as I understand it. DYRS elected not to implement this recommendation. And they say in part, during the construction phase of the YSC front lobby, DYRS relocated the front lobby, temporarily shifting control center operations. As a safety measure, DYRS utilized two-way communications, walkie-talkies, and deployed staff on foot patrol to monitor, identify, and report potential fire and life safety hazards. As of September 2024, the control center reopened on the first floor lobby and has the ability to monitor the facility visually via cameras and utilize two-way communications, walkie-talkies, to notify of a fire and life safety hazards. NFPA standards do not require NCC as part of fire detection and reporting systems, and DYRS is not required to install one. And what would be your response?
That is true. They're not required to install one, but this has an interesting history. As they referenced, between February and September of 2024, the control center was moved to a temporary location. In that temporary location, there was no fire panel at all. If there were a fire, if there were a fire alarm, staff would not have access to information about, the control staff would not have access to any information about where it is geographically. As we talked about earlier, control center staff, they're sort of the quarterback of the operation in the event of an operation. They need to communicate, stay where you are, move to another part of the facility. And in the absence of that information, they can't really do their job. An NCC panel in the short term would have been, you could install that in a location, in a secondary location. They're back to their control center now with the panel that's in a constant state of distress. Even when it's functional, the panel is 20 years old now and it's no longer supported by the manufacturer. But what that panel looks like, there's a single LED line of text that you can read out. That's adequate, that will do the job. But a more rapid response would be just a monitor with a graphic user interface that has some sort of depiction, a map of the facility that could say, you've got a fire in this specific housing unit. It just makes the response easier for staff. That's the source of the recommendation. They're certainly not required to implement it, but we urge them to, our experts urge them to.
What has the agency shared in terms of funding or other steps that are needed to act on these recommendations?
I think there are funding gaps in the area of generator replacements. Both facilities, we're told, need new generators. In the area of accessing fire dampers and the HVAC systems, these are devices that are designed to prevent smoke from traveling through a building in the event of a fire. Replacing the fire alarm system at the YSC. So there are funding gaps throughout. It seems like there's not a capital project schedule for fire safety that meets the needs right now.
Awesome. And one last question. What future assessments does your office have planned with DYRS?
Not related to fire.
Or yes, related to fire.
We will do follow-up on, our immediate concern is seeing whether and when contracts are put in place for these, and receiving that documentation. We still have a relationship with our experts, fire safety experts, and we can have them do reviews of those as they come out.
Okay. Again, this is something that the committee will be laser focused on. We have deadlines per the agency's own testimony coming up rapidly. My team is also working on a policy package for DYRS to address any number of deficiencies. I've been laser focused on the lack of services for young people at YSC, and that certainly will be a priority. But we too will focus on these fire code and safety recommendations, and I thank you for your work there. I will give you the last word. And just coming back to whether or not the facilities are safe.
I think that they do not have appropriate fire safety prevention systems in place at the moment. And that presents a significant risk to life and property.
Absolutely. Well, thank you.
Thank you
for
very much.
joining, and thank you for the report.
Appreciate it.
We are now going to move on to the second portion of today's hearing, and that will be testimony in response to Bill 26-0186, the Justice Involved Youth and Community Act of 2025, which was introduced by Councilmember Pinto, who also chairs the Council's Committee on the Judiciary and Public Safety. First, we will have Katerina Semenyova, Special Counsel for the Policy and Legislation of the Public Defender Service. I will have you join, and feel free to call others up. Good morning.
Good morning, Councilmember Parker. I'm Katerina Semyonova, Special Counsel for Policy and Legislation at the Public Defender Service. With me today are Hannah McElhaney and Brittany Mobley. Ms. McElhaney is a Deputy Chief within the Trial Division at the Public Defender Service. She leads the representation and supervises representation of clients in juvenile court. And Ms. Mobley is a Deputy Chief in the Community Defender Division, and she leads the Juvenile Services Program, which is in, as you well know, which is in the Youth Services Center and at New Beginnings, and serves youth there.
And it's worth noting, Ms. Mobley also joined that walkthrough on Monday.
Yes. So you're well familiar with Ms. Mobley. And so we testified, PDS provided testimony at the Judiciary and Public Safety Committee at the hearing on this bill, and we engaged with you and with Councilmember Pinto on that bill. I will not repeat my testimony today on that bill. We expressed concerns about the trusted adult portion of this bill. We expressed primarily concerns that One, an adult cannot be a truly trusted mentor for youth if they are required to report on that youth. If a fundamental part of that relationship is reporting alleged noncompliance of that youth to a probation officer, that it becomes a role that is duplicative of the probation officer and is not one that can be characterized as creating a trusted adult relationship. And secondly, we were very concerned with any notion that the Office of the Attorney General would be required to act in a particular way to terminate dispositions as a result of an allegation by a third party that they were in noncompliance, or even as a result of substantiated noncompliance, that youth need flexibility and rehabilitative solutions, and mandating a punitive one-size-fits-all approach is not the way to go in a program. But really what we wanted to do today was be here to engage in further discussion with you rather than repeating that testimony. So thank you for having this hearing.
I hear you loud and clear. In other words, let's just jump right in first. Thank you for being here. And thank you to members of your team. So you noted the duplicative nature of the bill with regard to supervision. Do you think the current supervision in place meets the needs of our youth, specifically those with these agreements set by the Office of the Attorney General?
Good morning. I'm happy to speak to that. I think structurally, yes. There are quality questions always in terms of who the supervising agent is and how much they see their job as reducing obstacles instead of just reporting on compliance. But structurally speaking, there is already a person whose job it is to determine what the child's needs are, to determine whether the child can be connected to those needs, and then to report on compliance. And that's the probation officer. All of these kids.
So I hear you parsing out structurally based systems versus the quality of those systems. It's worth noting that the supervision currently is set to court social services, which is not under the control of the district government. And I think, being transparent and honest, there are varying levels of quality that we hear about as it relates to court social services and their ability to engage in parole services, but any number of supervisory type roles. So how do we address the quality issue if you're acknowledging that there is a variance there as it relates to quality?
I think you've summed it up exactly right. And I think it is too bad that court social services, who is an integral player in this process, is not under the purview of this body, because it also seems a little wasteful to hire a second person to do the job the first person is supposed to be doing. So that I understand that there's something that can be done about that, but I just want to highlight that that doesn't really make sense. In terms of what can be done, I believe that court social services does report on children to the court effectively. That's not the quality problem that I see with court social services. They have a list of the conditions the child is supposed to be following. They have court dates in front of the judge, and they do say, here's how many times he was home for curfew, here's how many times he was not, here's whether he's been arrested in another jurisdiction. The reporting element of it is already being satisfied. The part of it that I think varies pretty widely in quality is the sense of personal responsibility for the success of the child. So whether the services exist and what the obstacles are to connecting the child to the services, the actual helpful part, the mentorship part, that's the piece where a support person as an available option could really supplement what's happening for kids.
So I'm going to ask you, not on behalf of PDS, but you. So do you think the mentorship component of the bill is worth pursuing?
I don't exist separate from the Public Defender Services.
Well played, well played, well played, well played. Or do you think, on behalf of PDS, that the mentorship component should be pursued?
No, I'm just kidding. I'm a district resident and a mother and a lawyer at PDS. And in all of those capacities, I do think kids need more than they are getting from the district. And I think the mentorship piece of this bill could be really valuable. I think both in terms of the actual services we provide to kids, the tutoring, the grief counseling, the cognitive behavioral therapy. There are a lot of things that kids really need and have trouble getting in DC. And the role of the person whose job it is to figure out intakes, transportation, cost, all of those sort of obstacle reduction
Yes.
jobs, that is a very valuable space in this bill that I think is worth preserving.
I go back to the young man on Monday who said, if I had a mentor or a big brother, I probably wouldn't have ended up in here.
Absolutely.
Which I thought was, it has stayed with me since Monday. And I'm hearing you in a nuanced way say the mentorship piece should be pursued and could be helpful, but more in a supportive role versus an oversight, punitive role that you think is already played by court social services and that they're doing that part pretty well.
Yes.
Okay. In your prior testimony, it was pointed out that the revocation of agreements as part of the bill's mandate would be inappropriate. We heard similar concerns by the Office of the Attorney General, separation of power concerns, as well as just overreach, I think are some of the terms that were used at the hearing before. Can you speak more about this and how we might make changes? Is it a matter of just striking that part of the bill, or are there ways that you think it could be tailored so that we don't have the separation of power issue?
Stricken from the bill. It's not just a separation of powers issue. It's a what's right for the youth issue. And the juvenile legal system is supposed to focus on the rehabilitation of youth. Mandating a single punitive response for alleged noncompliance is an inappropriate way to set a child up for rehabilitation. It doesn't give the district flexibility to say, okay, there's noncompliance, but really what's going on is that this relationship between the trusted adult and the youth is not working out. Really what's happening is the youth is not receiving the services that they need. The youth needs more trauma care. The youth needs a different mental health team. There's just no flexibility whatsoever to reach the rehabilitative goals, which is really what, if this bill is about helping youth with additional mentorship, with additional services, then the use of those services should be sort of fully beneficial for the youth towards that goal of rehabilitation, and not towards an end where the youth doesn't meet whatever goals are established for them, and therefore they have an additional punitive consequence in addition to all the punitive consequences that come from their court involvement already. I don't know if Ms. McElhenney wants to add to that.
No, I do agree with that. I'm so grateful that you went to YSC this week. That's the final stop for kids who are revoked on these agreements, and there's nothing really there for them. So the whole question is, what do we provide at the front end to prevent kids from coming into the system, to get the ones who are there out quickly? So the focusing on revocation is holding the kids accountable, but not the adults accountable. And I just think that's not great policy.
Focusing on revocation is holding the kids accountable versus holding the adults accountable. How do we hold adults accountable in the context of these youth with these agreements?
Right. I think when a court determines that certain services are necessary, or when the agreement between the government and the child determines those services are necessary, we have to look at whether those services really exist. A lot of these agreements recommend mentoring, and then it's hard to find mentoring. And when you find it, it's not necessarily great quality. So there's a system in place to say this child isn't attending, but there's not a great system in place to say, does it exist in the first place? And do you know why it isn't working for him? I mean, I often think that if everybody in the system's salaries were dependent on the success of the kids on their caseloads, we'd approach these kids really differently.
Point well taken. I do want to acknowledge, I see virtually there's someone under the heading of the JPS committee, or the Judiciary and Public Service. As I mentioned, Councilmember Pinto is supposed to join us. So I don't see her just yet, but I did want to acknowledge that it looks like she will be joining soon. Ms. Mobley, I wanted to come to you, and I'm going to ask this in a way that I think you can answer, because I know there's certain juvenile confidentiality requirements you have to meet. give me a rough estimate about how many youth are you dealing with regularly that have violated agreements of some kind, whether it's DPAs, DDAs, consent decrees that they violated that you're working with at YSC?
So I will say Ms. McElhaney actually may be able to provide a bit better estimate than I do, because the work we do with the young people there, we don't, quite frankly, don't ask that information and don't need it for the work and the services that we do, right? When the young people are at the facility, the point of our work in the juvenile services program within PDS at that point is to ensure that their legal rights are maintained while they're at the facility and advocating for supports and services that they need. So
And what does that look like, the advocating for supports and services? Because every time I leave YSC, I'm depressed because it's just like we literally are locking kids in a cell. And some people will say, well, that's good. That's what they deserve.
Yeah.
But there aren't any services. There didn't seem to be programs. There was no rehabilitation. The education, the extent of education programming this week, and you were there,
Yes.
was a 4-page packet that someone dropped off at 8:30 a.m. to a young person and said, complete by tomorrow at 8:30, you'll get a new packet. And if you turn in all of your packets by the end of the week, you may get a bag of chips. And to me, I just think we are setting ourselves up for failure. And there's no surprise why young people are leaving YSC and then recommitting instances of crimes and ending up right back. Last thing I would just say, I'm going to get off my soapbox.
Yeah. No, and I
Because I
agree
get
with you.
pissed off every time I'm there. It's like that we would not accept that for animals, let alone children, teenagers, some of whom said, oh, I've been here 7 times. I've been here 6 times.
Yeah.
This is my 5th time here, which again says what we're doing is just not working. All right. So you're advocating for services and programs.
Absolutely. And I agree wholeheartedly with your soapbox. So one of the things that I think we do here is consistently name the fact that this is an issue in the hope that there will, that change can be made potentially at a legislative level. But our immediate work is constant conversation with DYRS that this is an issue. Unfortunately, DYRS has not seemingly made it a value, quite frankly, that they deserve, that the young people are at these facilities deserve the investment for programming and support. One of the things I always say is we hear so regularly this word recidivism and kids coming back. In order, in this, this school to prison pipeline, this cradle to prison pipeline, how do we clog that pipeline if we're not doing things to invest in young people? So when we have district agencies not making a very deliberate investment, it is a very clear statement that we are not choosing to invest in young people. So what our team does, along with several other advocates, we have meetings with DYRS. We have meetings with General Counsel of DYRS. And oftentimes I use the word in those meetings, I am begging you to please provide programs to young people. We've heard comments and things in places that say, well, they're going to school, we're feeding them, we're housing them, we are, caring for young folks in this way, which is wildly unsatisfactory, I would note. But as you already noted, the education right now, I think Maya Angelou, who is the school at the facility, does a really good job.
That wasn't a good job.
Well, I hear you,
That
but
wasn't a good
there's
job.
also limitations, right? So when there are teachers who are in classrooms, I think they are educating young people. But when there is a scenario where kids are getting packets, where as you noted, and I will just, provide a little additional context, when kids are getting packets on a unit, every single young person we learn gets the exact same packet.
That's right.
These are kids with varying levels of educational needs. Some have IEPs, some have varying disabilities that impact their access to education. So being given a packet without additional support, when you have 9th graders, maybe a 12th grader, that makes no sense at all. And then what we're hearing from the school is, well, that's what our staffing numbers look like, and we don't have enough staff to provide that on-site instruction to everybody at that time. So those things happens too. But There has to be a deliberate choice made by DYRS to invest in young people, and they need to acknowledge that our young people in those facilities deserve it, and they are worthy of rehabilitation and an opportunity for change. But without the investment, it is a setup for failure for our young folks in the district.
I couldn't agree more. I did want to come to some components of the bill for those that may be watching and may not know what is this bill we're talking about. So I'm reading from the introductory letter that Councilmember Pinto penned. She introduced this bill alongside Council members Charles Allen and Anita Bonds. And then she gives some data. Well, she gives some context. The Office of the Attorney General enters into these agreements with youth as an alternative to prosecution or being held. Youth who are giving a DDA or DPAs must complete the requirements of the agreement in order to avoid prosecution or sentencing. Youth on these agreements must plead guilty in addition to completing the agreement. In 2023, there were 443 active DDAs, DPAs, and CDs for violent, dangerous property and other offenses, including 171 for violent offenses and 118 for dangerous offenses. As of December 2023, she argues 172 youth had completed their respective agreements. However, 89 agreements were revoked because the youth did not comply with the requirements of the agreement. Many of these youth needed more assistance to address the factors prohibiting them from complying with the terms of the agreement and to set them up for long-term success. Now, I'm just going to connect the dots. I think that's echoing some of what I just heard Ms. Mobley say, maybe not from the same vantage point, but our young people need more support is the headline. The current structure of the DDA, DPA, CD programs act as a checkpoint between the youth probation officer and the courts, but do not provide resources to help youth comply. That's also what we heard. And then the bill would do certain things. This is a pilot that would be run with DHS with about 50 participants. OAG will refer the highest need, highest risk youth for participation in the program. Trusted adults working with you should have a background or training in some of the following areas, including cognitive behavioral therapy, et cetera, et cetera, et cetera. The trusted adult will provide actionable support in school attendance and academics, assessing and navigating transportation for school healthcare appointments, after school activities and meetings, so on and so forth. The program will require monthly documented communication and follow-up between the trusted adult, the probation officer, and OAG to ensure the youth is meeting the terms of their DPA, DDA, or CD. Then OAG will be required to proceed with prosecution, disposition, or commitment. So I just want to level set with that's what this bill we're talking about called for. And what I've heard so far from PDS is that last component that would force the hand of OAG to prosecute or commit or revoke this agreement is what you all are pushing back on. In a nuanced way, I'm hearing the mentorship might not be that bad. Our young people need more support. And there's ways that we can advance that. What do you think about this relationship between that trusted adult, the courts, the parole officer, and OAG? Do you think that component of the bill is worth pursuing?
Not in its current form would be my answer. I would like to have the adult be a trusted adult. And in order to have a person in this process that a kid trusts and confides in, you can't make them another person whose job it is to talk to the prosecutor and the probation officer in the court, right? It's like saying your therapist is going to report on whether or not the content of your therapy is acceptable. It is really a good idea to have adults in the child's life, like their lawyer, who share a relationship where the child really feels like they can take risks and explain what the hardships are. That's how that person can be effective in connecting the child to services. Ultimately, the question of whether the child is complying with the agreement is supervised by probation, prosecution, and court. We don't need another person in that space, is what I would say.
Okay. I'll just say transparently, I'm not sold on that last part. Although 99% of what you just said, I agree with. But I do believe there's just something not working with court social services. And maybe that's just a consequence of our lack of statehood, that we just don't have control over that component.
Well, I think lack of statehood is a massive problem. I do think that there are problems with court social services, but I also, these kids that we're talking about in terms of this bill are shallow end kids. Most of these kids are very successful, right? Well,
And when you
really,
say shallow end,
they are kids who are released to the community, whose needs are needs that can be met on probation and in the community context. These are kids who benefit from sort of the exceptional circumstance of being offered a deferred prosecution agreement.
mhm,
And the vast majority of these kids live up to that promise. The vast majority of them do well under these agreements and don't get in more trouble. So we're talking about kids who are not coming in on offenses and with behavior so serious that they get locked up from the beginning. We're talking about kids who show that they can comply with court conditions, and that's why they're even offered a deferred disposition agreement in the beginning. And it's, I think, a little misleading to say these are alternatives to prosecution because you have to plead guilty to get this. It's just an additional incentive to do well, that if you do well and complete it, that you can withdraw your plea and the case gets dismissed. But you're very much on the hook. You've pled, and now the court has full authority to sentence you to commitment to 21 if you don't do a good job. But of these 443 kids who were on these agreements in 2023, the vast majority of them are completing the agreements and doing well. So
Yes.
I think
Yes.
inserting another person to find technical violations that get them trapped and pulled deeper into the system and toward YSC, that would be bad for them. It's the 83 kids who are getting revoked, where I really would love to have a person involved who could speak honestly to the kid to say, what's happening? What are you afraid of? What's going on with your family? What can I do as your mentor that would help you? And I just know teenagers enough to know that if that person is like on one side of their mouth, like, tell me all your secrets, and on the other side of their mouth, like, I'm going to tell the court and everybody else it's public, the child won't tell them, and they'll be in the same position that we're trying to avoid now.
so
I
game
want it
this
to
out
be-
for me. So
Sure.
what if the OAG says, okay, I have a young person that's violated the terms of our agreement. What I'm hearing you say is there should be some support for those youth too,
Before that, I don't want the prosecutor to say you violated. I want the prosecutor to be looking at the
before
child
they
on
violate.
the DDA and say, you are required to obey your curfew, attend school daily. I see that you're starting to be shaky. I see your attendance is starting to slip.
Yes.
I want to refer you to this trusted adult. Tell him what your obstacles are and tell him what your problems are. He's in that mentorship role for you. That kid may have a real serious safety concern about going back and forth to school that he's not sharing with anybody because he's afraid of what the system will do to him if he shares it. And he's not old enough or savvy enough to know that he's going to get in trouble if he doesn't go to school or if he shares. I would like to have an adult in that space where he can be honest with the adult and the adult can step up and help him and mentor him and reduce those obstacles.
I do need to move on to the
Yes.
next panel. I have one more question, but here's an invitation. This committee is going to formally produce comments to the Committee on Judiciary and Public Safety. I would love to work with you all, just gaming that out. What might that look like as a recommendation? Because you make a very compelling point, and I do think that is a current gap in the system. And so as a follow-up, we can see if we can find time soon, because we have to get these comments in by the end of the month. But I welcome that. It's worth noting that young man that I talked about that said, if I had a mentor or a big brother, I wouldn't end up here. He also said he wasn't going to school. And he had this reflection like, yeah, I'm gonna fail this year. I'll try again next year. So there's something there, to your point, that we just have to wrestle with. Final thing, in your previous comments, you proposed allowing school staff or community-based organizations to refer youth for voluntary mentoring services from a trustworthy adult who can help them navigate challenges. Are there district or out-of-district programs that you think fit this recommendation or could be a model for us to look to?
Yeah, the first thing I'm thinking about is the YAP model, YAP. I think it's Youth Adolescent Program, maybe. I believe they have it in Maryland. I'm looking, Youth Advocate Program. Sorry, I'm looking to my colleagues who I knew would know. And the other thing I would just highlight
Can
really.
you just describe generally that program?
Yeah, it's sort of a mentoring program. These are often folks who have been system involved themselves and are doing well. And they're akin to like credible messengers, which we know are often success stories and are good folks for young people to look up to. The Sentencing Project issued a report called Why Youth Incarceration Fails, I believe in 2023 or 2024. And then they had a subsequent report with some recommendations, which is really phenomenal. It's evidence-based. It's an amazing
What's the name of that
report.
report again?
Why Youth Incarceration Fails. It's with the Sentencing Project, and they have a lot of recommendations as to what works for young people and keeping young people in community and how young people we can be successful. A lot of that does, again, to the earlier comments, require an investment in community for young people to be successful in avoiding situations before they meet folks like Hannah and I.
Understood. Well, thank you all for your testimony today.
Thank you.
Thank you. We will move on to our next and I believe final panel. We have Janice Patterson. I'm having a moment because I refer to her as Mama Joe. And so I think this is one of the few times I've actually seen her first name. Mama Joe, Janice Patterson, is the founder of Parent Watch. We have Eduardo Ferrer, Policy Director of the Georgetown Juvenile Justice Clinic and Initiative. Joshua Miller, Research and Advocacy Director of Open City Advocates. And Tracy Velasquez, Policy Director of the Council for Court Excellence. And I will entertain your testimony in that order, starting with Mama Joe. And if you can hit the mic so the red light is showing. Awesome.
Good morning, Councilmember Parker and staff and our guests. Anna said a whole lot of what I wanted to say, but I'm gonna go on and read my testimony, which this morning I wrote because last minute. Anyway, testimony in support of Bill 26-186, Justice Involved, Youth and Community Act of 2024 Pilot Trial. That's my feel. Hello all, I am submitting this testimony in support of Bill 26-186, the Justice Involved Youth and Community Act of 2025, with the strong recommendation that this legislation be launched initially as a pilot program. While the intent of the bill is commendable, the current language lacks clarity regarding to two critical components. Who qualifies as the trusted adult in the eyes of the law? And which agency or organization will administer and provide oversight to ensure proper implementation, accountability, and outcomes, and also things that fail as we go through the process. As the bill stands, it leaves open the possibility that anyone could fill this trusted role, potentially undermining the stability, structure, and long-term impact that the program seeks to establish. While Parent Watch is the right organization to lead this pilot, without vanity, y'all, Parent Watch is uniquely positioned to administer this pilot program with fidelity, cultural competence, and cultural humility. Trust already established within the justice-involved youth community, the courts, all of y'all guys. And so for years, Parent Watch has built an authentic rapport with youth and their families impacted by the juvenile system, particularly those under the supervision of the Department of Youth and Rehabilitation Services, the Family Court, the OAG, MPD, and all of those entities that touch our families and youth. DYRS, our team's work goes far beyond surface level engagement. We provide intensive wraparound support that prioritizes healing, accountability, and personal growth, and especially family reunification. We have a long-standing history of direct collaboration with DYRS, defense attorneys, judges, schools, and families. We are often one of the few organizations trusted to enter the homes of system-involved youth and serve as a credible bridge between agencies and the community. Our track record includes mediating family conflict, advocating in court hearings, facilitating youth-led restorative circles, and supporting reentry transition, and also helping build good legislation and policy, and working with all of our advocates, the Children's Law Center, across the board. In short, we are not outsiders to the youth we serve. We are recognized as respected allies. And as you saw yesterday, they want us to come in defending them and treating them like human beings. This foundation is critical for a program that relies so heavily on trust, consistency, and proximity, existing rapport, and capacity. Our relationship with the youth are not transactional. They are relational and sustained, before, in between, and after. Many of the young people currently under court supervision have existing ties to our mentors and advocates. We have, and I also want to add, we have relationship with retired judges, lawyers, just to ensure that they understand the law. We have worked with them in moments of crises, through violations and setbacks, and during milestones such as completing educational benchmarks or securing their first job or getting to court on time. This continuity makes us a powerful partner in facilitating and meaningful change. In addition to youth rapport, Parent Watch has existing collaborations with DYRS, Credible Messenger, Court Social Service, District Defense Attorneys, and Juvenile Advocates, CBO, and federal level with the Department of Justice. CBO's focus on education, mental health, and workforce. And I want to shout out also Easton and Georgetown. We do the Early Childhood Innovative Network, and we're one of the co-founders of that project. We also have data collection system, raw data, accurate data for things that people don't report. Okay. We also have ensuring that pilot is not just implemented by evaluated and improved in real time. Recommendation. I urge this committee to move forward with Bill 26-186 in a pilot capacity to formally name Parent Watch as the operator of the initial program phase. Our deep roots in this work, proven commitment to youth transformation, and cross-agency partnerships makes us the most equipped organization to deliver, document, and refine and redesign this initiative before any broader rollout. Thank you very much.
Thank you. And then you can push that button to cut the mic off. There you go. There you go. Next, we will have Eduardo Ferrer.
Good morning, Chairman Parker and members of the Committee on Youth Affairs. My name is Eduardo Ferrer. I'm a Ward 5 resident, the Policy Director at the Georgetown Juvenile Justice Initiative, and an Associate Professor in the Georgetown Juvenile Justice Clinic. Thank you for the opportunity to testify today regarding Bill 26-186, the Justice Involved Youth and Community Act. While I appreciate and support the very big picture intent of this legislation to provide system-involved young people with the services they need to succeed, I oppose the passage of the Justice Involved Youth and Community Act as drafted for a host of reasons. First and foremost, while I believe we need to better support system-involved youth generally, the bill's focus on youth who are on consent decrees, DPAs, or DDAs is misplaced. This focus is premised on the idea that the manner in which consent decrees, DPAs, and DDAs are being used in delinquency court requires the DC Council not only to specify that certain youth subject to these agreements receive a very particular intervention, but also to mandate a new process for determining whether such an agreement should be revoked. Essentially, this bill appears premised on the idea that these agreements are not working and somehow make us less safe. This is just not the case. The aggregate data shows that these agreements are used judiciously. For example, for delinquency matters opened in FY23, fewer than a third involved youth entering a consent decree, DPA, or DDA. Additionally, these agreements are an effective tool that rewards hard work and compliance with conditions of the agreements while reducing the collateral consequences that come with the delinquency adjudication. Data from the Criminal Justice Coordinating Council indicates that 86% of youth on a consent decree, DPA, or DDA during calendar year 2023 were not arrested in that calendar year or not rearrested in that calendar year, and approximately 2/3 successfully completed their agreements. Moreover, violent crime generally and youth arrests specifically are down significantly since DPAs and DDAs were meaningfully introduced in delinquency court in 2015. Indeed, as DDAs and DPAs became more common, violent crime and youth arrests each separately have fallen approximately 45%. Importantly, I'm not saying that violent crime and youth arrests have been cut in almost half in 10 years because of these agreements. I'm not making a causal argument. I'm saying that there's little evidence that there's a problem with the manner in which these agreements are currently being used. Second, in addition to this bill being a solution in search of a problem, there's little evidence to suggest that the solutions proposed in this bill would provide some marginal benefit. Indeed, it is difficult to even assess the idea of the Trusted Adult Program, given that the bill does not specify which executive agency will run the program. For instance, the design and implementation of the Trusted Adult idea will look very different if DHS, DBH, or the ONE's office were tasked with running the program versus an agency like DYRS. As a result, without knowing who would run it, it's hard to assess how it would be run. This difficulty is further compounded by the breadth and vagueness of the definition of trusted adult. There's no definition of what qualifies as demonstrated training, certification, or other qualifying experience. And the qualifying of areas of expertise range from psychology generally to cultural competency broadly. Third, even assuming there was a more detailed program model, an assigned agency, and an evidence base supporting the program, the legislation as introduced would conflate, realign, and infringe upon the proper roles and responsibilities of various existing delinquency system stakeholders. For instance, in requiring that OAG assess, identify, and refer youth to the Trusted Adult Program, the legislation would force OAG to usurp roles that CSS currently plays and is better suited to play. OAG does not have direct access to the young people, nor does OAG conduct any of the assessments of the young person. In contrast, court social services probation officers meet with the young person and their family, conduct home and school visits, receive copies of any assessments from the child guidance clinic, and supervise the young person in the community. As such, CSS is better positioned than OAG to meaningfully assess the risk and needs of each young person and make referrals accordingly. Additionally, while the bill as drafted assigns OAG a role that is better suited to court social services, the bill as drafted envisions service providers encroaching upon the monitoring and reporting role currently played by court social services. As others have discussed, I won't belabor, this approach risks undermining the trust that youth and families have in trusted adults. Finally, the bill infringes on the prosecutorial discretion of OAG by arguably shifting the power to determine whether a DPA or DDA should be revoked away from OAG to CSS and a trusted adult. DPAs and DDAs are agreements between OAG and the child. As a result, OAG has sole discretion to determine whether the youth has been substantially compliant. In contrast, the bill as introduced requires OAG to consult monthly with CSS and the trusted adult and leaves vague who has the power to determine whether a young person has substantially complied with their agreement. Given that the legislation requires that OAG revoke if a determination has been made that a youth is substantially non-compliant, the bill as introduced appears to give power to CSS and trusted adults to determine for OAG when OAG must not only revoke an agreement, but also proceed to disposition after such a revocation, even if OAG believes that an alternative intervention would be more effective. As such, the bill infringes not just on OAG's role in determining whether the youth has substantially complied, but also OAG's discretion to determine what next steps to take after the revocation of an agreement. In conclusion, while I very much appreciate the intent of the bill and would be happy to work with this committee to find ways to support that intent, I cannot support its content. Thank you very much for the opportunity to testify today, and I'm available to answer any questions.
Thank you. Next, we will have Joshua Miller.
Good morning, Chairperson Parker. My name is Joshua Miller. I am the Research and Advocacy Director at Open City Advocates, which provides legal representation, holistic advocacy, and mentoring to youth who have been committed to DYRS. So my colleague Whitney Lockheim previously testified before the other committee on this bill, and I endorse all of her detailed discussion and the research she shared, her own experiences. Our primary concerns with this bill are threefold. It creates a third-party monitor known as a trusted adult who is charged with revoking the DDAs and DPAs, despite the fact that this role is already adequately filled by the Office of the Attorney General and the officers of this Court Social Services Division. It presents this monitor as a mentor who will ensure that the provision of needed services, despite monitoring and mentoring being diametrically opposed roles. And it places pseudo-mentees in a position where revocation is likely to undermine the benefits of mentorship and indeed create feelings of self-blame and abandonment. By way of extending that analysis, I just want to briefly discuss the sort of Orwellian term trusted adult itself. Creating stricter standards for alternative prosecution tools appears to be a policy in search of a problem to solve. But the overall emphasis on mentoring is novel and indeed laudatory. While the term has many different usages, the National Alliance on Mental Illness defines a trusted adult as someone who offers support, encouragement, and a role model for action, someone who talks rather than tells, and someone who acts as a neutral part of a child safety network, all of which is at odds with the pseudo-supervisory role envisioned by this bill. Research about mentoring best practices suggests that a punitive approach to mentoring doesn't work and can indeed backfire. In the largest meta-study to date on the use of mentoring in the juvenile justice context, the data showed that the most successful programs paired mentors with mentees for more than a year, used careful closure processes, and encouraged mentors to advocate on behalf of their mentees. Mentors should be allowed to be fully partisan, taking their mentee's side, because an unconditionally supportive adult is what every flourishing child in their has in their lives, and what we owe to children who encounter the abuse, neglect, and delinquency systems. We shouldn't be subjecting children to additional adverse childhood experiences as a part of a process that is supposed to be trauma-informed. We already lack adequate mentoring services in the city, and it would be better not to co-opt that role with additional surveillance that will increase the number of children in the institutional end of the system. I want to be clear that the idea of mentors for youth at this stage isn't bad, though it may not be the place where we most need the intervention. It's only the dual mandate of support and surveillance that makes this trusted adult potentially detrimental. You can read the rest of my testimony, but like PDS, I want to just withhold as much as I can and get straight to the conversation.
Awesome. Thank you. And then last but not least, we will have Tracy Velasquez.
Good morning, Chairman Parker. My name is Tracy Velasquez, and I'm here as the Policy Director for the Council for Court Excellence, which is a nonpartisan nonprofit organization dedicated to justice reform here in the district. So like some others here, we testified, Magdalena Tongas testified at the JPS hearing earlier, and I don't want to reiterate her testimony, especially since all the folks here pretty much hit on most of their points. But I did want to note on some of the issues that I feel like maybe didn't come up as much as, or should be raised additionally. Again, like I think everyone here, we see the issue of having mentorship for young people as being an evidence-based practice. We actually know that adverse childhood experiences that many of these youth have had can be somewhat mitigated by pro-social experiences such as having an actual trusted adult mentor in their lives. And so the idea of giving more youth mentors certainly is something that is evidence-based and we support. Some of the points that I felt maybe we should talk about is the involvement of family. And Mama Jo mentioned the involvement of family as in this process. Also, these youth are going home to their families, and I haven't heard anything about what supports these families might need to help the youth be successful. Is the family, for example, having financial difficulties? Are they having housing instability? What are the issues? Is there a need for, CBT was mentioned, but I don't really understand to what extent families are getting the support they need to help the youth be successful on their diversionary program. The second is folks talked about revocation and this sort of whether even legally it makes sense for this legislation to take away the discretion of the Attorney General's office to decide whether to revoke. There are decades of evidence-based practice that incentives work better than sanctions. And this works for adults, this works for kids, it works for your dog, right? This is just basic behavior. And to not have a program that focuses on incentives rather than revocations means you're creating a program set up for failure. We should not be focusing on revocations, particularly, I think this is after 3 months. If a family has gone off Medicaid and they can't get services, are they going to be able to be put back on Medicaid in 3 months? Are we going to be able to find a child psychologist in 3 months? We don't know the funding landscape. We don't know the availability of professionals at this point for the potentially complex needs some of these kids might have. So to revoke a child, someone said you're punishing the child for what may be failures for adults, and I think this could be the case here. I wanted to also talk about interagency collaboration. As you know, CCE did a report on crossover youth, which is youth who are duly involved or have been duly involved in both the child welfare and the juvenile justice system. The main point of that report, and it was actually the title of the report, is that DC is failing at interagency collaboration for justice-involved youth. We've seen this across agencies, even within the District of Columbia. So we're talking about CFSA and DYRS who can't seem to work together for the best interests of youth. Now we're talking about a federal agency, CSSD, which has we have no authority to mandate that they do anything, right? And who knows what their funding landscape might look like 6 months, a year from now, and their ability to participate on a higher level in a project that really depends on close collaboration between entities. I just don't see this as a feasible working program if, I don't see anyone here from Core Social Services supporting this and saying that they would like to have these additional mentors as a resource for these young people. And then finally, I wanted to talk about the fact that this program doesn't expand the use of these diversionary programs. We just heard that YSC is a fire trap, and that the fire programs at both YSC and New Beginnings are problematic. We know that YSC has been over capacity now, off and on for the entire year. I think there's like 100 kids in there with a building not meant for that many. So we should be trying to keep youth out of these facilities. We know that youth are awaiting placements now who are committed to DYRS. So the only advantage I see is to see if providing youth with more services, including mentorship, might allow, I think they talked about this being the shallow end of the pool. It would be great if we could get more kids who are in, the 3-foot depth or the 6-foot depth of the pool onto these agreements as well, so that we can keep them out of these facilities, which are not providing the rehabilitative services that we would hope they could provide to youth who are obviously having challenges in their lives. So thank you very much for this opportunity to come back and testify for your committee.
Thank you. Thank you. And I'm going to shift to questions. Mama Jo, I'm going to start with you. You noted that you are supportive of the program and believe that Parent Watch should be tasked with standing up the mentorship component of the bill. And I noted you didn't mention the revocation part. Have you weighed in on that, or are you supportive of that part of the bill as well?
I'm gonna be very honest. I was in the back room writing this just a moment ago, but just in a natural language, what everyone has said, even back to Anna about our youth and the trust. Not only that, I have issues with investigation, detectives, MPD, and how they interact with our youth. It's not a good taste for me. And so I just feel you have to be very honest, this whole bill, we do it already. We play this role already, calling, talking to federal side, and everyone. We already do it, sit in the judges' chambers, and we rumble sometimes, but still, it's done. And so all of this, everyone knows I'm pretty natural. All the dress up stuff, I try to talk very clear. Yeah. So my community that listens to me, my children that listen to me, and the parents. I think Anna talked about the youth that maybe possibly does not qualify. So what do we do with that population? They're still going to come into our community. So when we look at this, we have to also, during this pilot program, all of us need to once a month meet to find out where, I don't like the word gaps, where the reality is and where the real problem is.
Let me ask it this way. So the Office of the Attorney General, as an alternative to I shouldn't say alternative prosecution because they are pleading guilty. But an alternative to commitment, they're saying, young person, we're going to put you on this alternative agreement that you may have to go to school, you may have to see someone weekly, you have to do these things. That young person violates that agreement. We've heard data that the majority are meeting the agreements, but there is a subset of young people that are violating those agreements. In your experience, what do you think is best that the system do for those young people that violate?
Well, it's a lot of things. Families, the conditions which they live in. A lot of them really come to the facility because it's a bed and 3 meals. And I have youth that tell me, Mama Joe, I've been here 11 times, and I have to talk to them that that's not a gift, but it's a bed for them. Same thing with sometimes carjacking. That's a bed for them. So when you say, how do we do that? Everyone says wraparound services, but I will say crises intervention. And also, you talk with a young man that talked about his mom. And the strength of that child to want to take care of his mom and his siblings. Just imagine if we heal that parent, work with that parent. We have young people that are taking care of the household because they're forced, because the system is not set up to deal with intervention. I get maybe 20 calls of a crime parent all life calling the facility to see if the child can come up there to see the jail. And I tell them that's not no way to do it. You know, what other services you need? Good parents, lawyers, doctors. I mean, our children the good children are being bullied by, and I don't want to say bad children, but bullied by children that don't have what the good child has. So, you know, I just think that we need to build a lot of strong, natural, and informal resources that work, but it's not documented. It's not put into all of this data and this evaluation. It's just talked about, you know, community grassroots, boots on the ground. No, start writing it in the integration of funding.
Absolutely. No,
Okay.
thank you for that. Mr. Ferrer, it's always good to see you. Thank you for joining us. You spoke about the ambiguity surrounding which agency would house this program. Do you have, if we were to move forward with the bill as written or components of the bill, are there agencies you think might be best suited to house this type of program?
Yes, I think DBH or DHS are probably best suited to house the program. I do think it then calls the question of why we're creating a new program rather than investing in existing programs that already are there. For example, high fidelity wraparound. It's an evidence-based program. We don't utilize as well as we should the slots that we already have, and does a lot of what is behind the impetus of the trusted adult role. And so I think either of those two agencies could be a place where this lands. But I would also say that one of my fundamental issues with the bill is the nexus between the launch of a pilot program of supports for young people and the nexus to consent decrees, deferred disposition agreements, and DPAs. There really should not be a nexus. If we're going to provide support to young people who are system involved, let's provide that support. Let's not tie it to these agreements, which all the evidence seems to be showing are working pretty well.
So how might that type of mentorship program be structured? Every young person in the system would be assigned a mentor? Is that what you're getting at?
No, I think it comes back to the fundamental principle that underlied the Road Act as well, is it's got to be tied to the research and the evidence, which is a risk needs responsivity analysis. So someone's got to be analyzing, is this young person low risk? Are they medium risk? Are they high risks? What are their needs that if we address them, mitigates or reduces that risk? And then is a mentorship or a trusted adult program what that particular individual needs in order to be successful? And so it has to be.
But doesn't that run counter to what I think I've heard is that once, yes, everything you said, I think resonates, but in some respects, once they're already in the system, it's late in the game. We want to prevent as many young people from entering DYRS as possible. So
Absolutely. And still within that system involvement, there are low, medium, and high risk kids. There are kids that I have who quite literally we could do nothing and we will never see them again. And that's exactly what we should do with those kids is nothing. There are kids who have experienced tremendous amount of traumas that they're going to need extensive, deep support over a prolonged period of time to really help them get back to a point of healing and thriving. And we need to be approaching those young people differently and on an individualized basis. I will add one other quick point on this because I didn't highlight it in my proactive testimony, but I would be remiss not to mention it, is I also don't think, while I do generally love this idea of a trusted adult, divorced from any tie to the agreements, I don't think it's going to be the silver bullet that folks hope it will be. And I say this to say that when I read the legislation, it was a proud father moment for me in the sense that my students do this in all their cases. They transport kids to and from school. They make doctor's appointments for them. They're the ones tracking down DBH and the core services agencies to set up appointments and make sure kids get them there. When families don't have food, they're finding donations and they're taking grocery cards to the families' houses. They are pushing on schools to implement IEPs. They are doing all the roles that this trusted adult is supposed to do. And either there are not programs responsive to the needs of the young people that are willing to, in a timely and high quality basis, actually engage with that young person and their family, or our students are facing obstacles at every turn trying to connect young people to the services. I'll give you one basic example. Young person, DDA, had to complete 30 hours of community service. This young people is a full-time IEP student, has to transport an hour and a half every way to his out-of-district full-time educational placement. Does not leave a lot of time for community service. Young person's young. There aren't a lot of places in the district that will do community service with the young person by themselves. Because of that, my student found, through the Humane Society, the opportunity to make blankets at home for community service for dogs and cats in shelter, and then proceeded to do all of the young person's community service with them to ensure that they were able to complete their DDA agreement, right? There aren't all of these things that we want the trusted adult to be able to connect them to. Those programs, in theory, in many cases on paper, exist in DC. Accessing them for the young people who are system involved is exceedingly tough. And to be completely frank, tougher than it's been in the 20 years that I've been doing this.
And that echoes part of what we heard from Mama Jo, that a lot of this is already happening in informal and formal ways. And I think, Joshua, you mentioned this too. Let's scale the programs that we already have versus replicating things. You noted, and you gave like some numbers, that fewer than a third of these agreements have been revoked because of non-compliance. Yeah, go for it. 2/3, so this is from CJCC's data. 2/3 of the agreements that ended either because of successful completion or revocation that year were successful. 1/3 were revoked, but a fewer number of those kids, it looks like, was revoked because of a rearrest. So a number of those kids were revoked purely for non-compliance, which could be for a host of reasons, including difficulties in school, difficulties with curfew, running away, et cetera. I mean, I don't challenge that. And I guess maybe I shouldn't share this, but I share some of the concerns that have been voiced here. And I've talked pretty openly with Councilmember Pinto about that. I had this moment when I was speaking with a dad, and I shared this at the hearing that Councilmember Pinto had, where the dad was saying, I don't know what else to do. My son is on parole, but its parole officers aren't doing what they're supposed to do, and he's crying out for help. I'm sure that's just one data point, and there are many others. Again, I'm clear-eyed that court social services are probably not doing all that they can do to support our young people. Outside of us being able to mandate that they do this or that, what I see as the intention behind this bill is an effort to stand up something that the district could provide support. I get the overreach and the concerns about revocation. what I'm getting at is for those young people that are trapped in cycles of violence and or for whatever reason just are not complying, they're not abiding by the support systems that already are in place, based on your experience and expertise, what would you point our committee to emulate, to look to model after as we are considering this legislation?
It's a fantastic question, and we do hear from parents a lot. They're frustrated, right? They've been looking for services and trying to connect their young people to services well before they've ever become system involved.
That's right.
So by the time they even get to court, parents are already frustrated because they don't feel like DC is showing up for their young people. I can give you a couple of examples of, I think, what's happening and where you can focus to maybe accelerate or improve changes that have happened. One is we don't have a plan. The district doesn't have a plan.
A plan.
A continuum of services, an actual continuum of services, right?
Yes.
The Criminal Justice Coordinating Council received a grant from DOJ to identify the continuum of services in the district and identify where those gaps are. My understanding is they have since hired a contractor to help with that. So that is in progress. It would be great to find out how far along are they, when are they going to have the report, and then utilize what they produce to figure out where the gaps are, how we can fill those gaps, and how we can really have an intentional continuum of services, ideally even pre-system involvement that families can tap into and really, and not just drive the numbers down of youth who get system involved, but better support those once they cross that threshold. So that would be number one. Number two is programs that we have that work, great evidence-based programs like MST have recently closed. We've worked with your committee staff to look into this, and they've been very responsive and helpful in figuring out why it is that the one MST provider that we had in the city recently stopped offering those services. And the answer was because between DYRS, CFSA, and one other agency, they weren't getting the referrals they needed in order to actually keep the door open. I have kids, we're begging for services and we can't get them. And for whatever reason, they're not getting the number of...
Who's in charge of those referrals?
It can be from any agency. It can be from community-based services, et cetera. We call the Access Helpline. We ask for services, and I'm not sure why it is that they're not sending them to, it was MBI who was providing MST services for young people. And now MST is a intensive intervention, right? So as we're talking about the kids with the highest need, MST is a fantastic community-based intervention, wealth of evidence behind it, very effective, that helps stabilize and keep kids in community and keep kids from reoffending. And now we've lost the only MST provider that we've had in the city. So we have to ask these questions about why is it that we are not talking? I was looking at DBH's oversight answers in preparation for this hearing as well, and the timeline between referral through the Access Helpline and actual connections to services keeps continuing to get longer and longer year by year. Why is that happening, right? We are failing on a host of fronts, right? And so while a trusted adult could help fill the gap in some ways, they are going to face the same barriers that young people and their families are already facing, which is, fantastic that the young person now has another person, an irrationally caring adult in their corner. But until the district steps up and meets its end of the bargain, we're not going to get the outcomes that we want to see.
Thank you for that. That is really helpful. And those recommendations we'll make a point to include in our formal comments to the Committee on the Judiciary and Public Safety. So if you have others, please share them with us. Joshua, Miller, I wanted to come to you. You spoke about some of the best practices with regard to mentorship, particularly including unequivocal support and advocacy for youth versus coupling them with this big brother type role. Like, are you complying with your DDA or DPA, et cetera? Aside from striking the monitoring portion of this bill, are there ways that you think we should adjust the bill in order to make it viable?
I mean, pairing is an art, but it requires voluntariness. And the way the bill is currently structured, it looks as if OAG has to sort of assign certain young people to a mentor. They might be asking the young person if they want this trusted adult in their life or not. But I would say, make it up to the young person whether this is something they want in their life. And they'll be much more likely and much more responsive to that young person. And then potentially give them some idea of who the available trusted adults are so that they can make a selection, right? I mean, I hope that you've had great mentors in your life. I know I have. And every one of them has been, sort of a little bit of a negotiation, like getting to know someone, deciding that they're a good fit, working with them for a time, and then usually ending the relationship after a longer period of time. That doesn't mean that, in this coercive context, there can't be an opportunity to sort of very strongly push some young people who need it most into this space. But, mandated therapeutic interventions are less successful. Mandated mentorship is also going to be less successful. There's a need. Children know when they need this need, so let's just ask them.
I buy that. I'm still grappling with for the hard to reach youth, that there are already any number of systems. Like, what are we doing for them? And I agree with Mr. Ferrer when he says, like, ideally, we're doing this before they encounter the system or before they are in non-compliance of whatever agreement that they have. And I'm asking the same question over and over because I guess I'm looking for a tangible outcome, and I know it's not that simple. I did want to ask about this. I wanted to go back to something Mr. Ferrer said, that the bill calls for OAG to make the recommendation, but he argues that's the role of court social services. And it would require these trusted adults to advise on compliance when that's the role of the OAG. And it would force the hand of the OAG and not give them any flexibility to negotiate and forcing them to revoke these agreements. I guess there's the list of a question there, but I think that's a compelling point that hasn't really been parsed out here, that we're tasking OAG to do something that, if there is not a clear communication channel between court social services and OAG, they would not be equipped to do, which is to make the referral, unless every young person that would be assigned an agreement would automatically get one of these mentors. I don't know if you want to comment on that.
I mean, the one thing I would like to comment on is that, like Eduardo, I find the focus on, first of all, consent decrees, right, which is, a totally separate kind of agreement from the DDAs and DPAs. And then these alternative prosecution tools really confusing, right? So they came up in the Uplift bill. They came up here. It's clear that there's a concern, but there's not clear why. If we want to talk about kids who could really, really use a trusted adult in their life, it's,
But we do know why. And while I don't want to speak for Councilmember Pinto,
Sure.
I think there's this suggestion, this notion that we're not locking up as many young people as we could, or some would argue that we should be. I mean, that's the transparent response, that some would say we need to lock up more youth because if we do that, we would improve safety in the district. That goes back to what we were talking about with PDS, that we know at a minimum, roughly the last data we have, 50% of young people leaving DYRS are coming back for a new crime. And I invite anybody to just go to the facility, and it's abundantly clear why that is. That I would imagine we are radicalizing young people when they go into YC or DYRS. We're harming them and making it more likely that they're going to go out and commit a crime based on the lack of services, programming, and trauma that is happening within the walls of that facility. Back off my soapbox. That is why there's this implied notion that we have to do something with these agreements because we're not locking up enough young people.
I agree that what I was about to say was that if we were going to focus trusted adult resources, right, if mentorship is a finite resource, we were to focus those resources somewhere, I would think that focusing real mentorship on people in community after commitment might make more sense. These are people who, as you say, have a pretty high failure rate, higher than for these agreements. And so that might be a place to put our emphasis.
Wait, say that one more time. I'm trying to wrap my mind around
Okay,
this.
so
So
here we have
af-
these
after commitment.
after commitment.
We
And
would do what?
After commitment, after you're released from New Beginnings, right? Those are the people who need these resources, not the folks at the shallow end of the system.
Interesting. Well, that is something that this committee is working on because I wholeheartedly agree. There is needed support for young people that are leaving commitment. The last time I was there, re-entering school alone was a very traumatic experience for the young people, as they said. They were behind, their records weren't transferred, they are getting run back and forth, and they don't know where to go. So that is a compelling point.
And none of Open City Advocates' clients are getting placed in schools by DYRS. We're doing all that placement work ourselves. So I'm not saying that's a universal problem. There are tremendous needs at that end of the system.
That's right.
I would just ask.
If we were to set something like that up, who should oversee that type of program? Because that was the other big question. DYRS would say, well, their commitment with us is over. We shouldn't have responsibility. The OAG says, well, maybe it's not appropriate for the prosecutor's office to continue support or oversight. Where should we stand up that type of program?
I mean, my familiarity with district agencies outside of DYRS is limited enough that I shouldn't speak, but I would defer to Eduardo's expertise.
Any ideas where we could stand up
can-
that type of program for young people once they're exiting commitment?
So I think let me talk about 2 process points. One is reentry. So a young person who's leaving a facility but is still committed to DYRS. So they're still going to be under DYRS's supervision. I think it would make sense for there to be resources at DYRS to provide that level of support to young people who are still committed but reentering. Credible messengers actually do a lot to fill this role now. So it would be about better supporting credible messengers, expanding that program, scaling it up, and empowering them to play this role of trusted adult. I actually think that's a fantastic fit. And what they need is again, coming back to values, we need to support and actually care about supporting young people and giving them what they need to be successful in the community, and not just a focus, as you pointed out, on this idea of incapacitation or incarceration in facilities that are providing little to none and actually causing more trauma. So that's process point 1. Process point 2 is, for a long time, DYRS was offering voluntary services to young people after their commitment expired. So if a young person was engaging in therapy or engaging in a program that DYRS was paying for, and it was helping them, the idea was, well, we're not going to cut this kid off because this is working. So the agency is going to continue to support that young person. There's no legal requirements. The young person can stop at any time, but so long as they're continuing to take advantage of these services, then DYRS will continue to support that young person. I think we should look at that and whether that's happening on the scale that it was happening in the last few years under the prior administrations. And to the extent it's not, whether there may be other places, other agencies, DHS, maybe through DOES. At that age, young people are really looking to transition more to workforce. What other agencies we could place this idea of a trusted adult in to support young people who are post-commitment?
Really helpful.
Let me just add one thing. Is my understanding is that credible messengers aren't able to take on this irrational partisan perspective when it comes to DYRS children any longer. And that's something that we've observed for our clients and their relationships with their credible messengers. The DYRS is saying, no, you work for us. You don't really support the child in the same way. And that transition has happened relatively recently. So insofar as I think that the credible messengers I know.
Say more about that. That
They're
they
not able
are
to-
not empowered to advocate for the youth.
Exactly. Right. So this is one of the things that we think is most important for someone in this role, is this empowerment when it comes to advocacy. And what we've observed is that they're not able to say, speak at a community status review hearing on behalf of the child. And we think that that is undermining their efficacy, and it's not great for morale either.
Can I just actually build on this point? Because I think it goes back to Mama Joe's point.
We're
about-
flowing. The
about
clock is running,
yeah,
but we're flowing.
about the importance of community,
Yes.
right? And Ms. Mobley referenced the YAP program, right? It is a odd thing to create a position within DC government that has to fight the rest of DC government to get for that young person what DC government is saying they should have, right? And so whether it's a credible messenger now being reined in by DYRS and saying, no, you're not going to push on that school to try and implement this IEP differently, or you're not going to go hound DBH or DOES to provide services to this young person, or you're not going to call them out on their failures because now we're calling out brother and sister agencies. We're setting up kind of these perverse relationships and incentives that ultimately what ends up happening, and this is back to Ms. McElhenney's points from earlier, we don't hold the adults accountable, right? The adults all point fingers at each other or cover for each other. And the kid is the young person who gets scapegoated or blamed when they're not succeeding or thriving the way they should because those services were never put in place in the first place, right? And so community has to be at the core of whatever solution that we adopt. And as we're looking at this continuum of services, right, centering community, the solutions they want, the programs they want, and centering them in the design, implementation, and execution of those programs is going to be critical, both because that's who young people are going to trust and because they're going to have more
They can actually be a
ability.
check on the system.
That's exactly right.
Yep. I'm sold. I'm persuaded by that. Ms. Velasquez, I'm sorry. The men were hogging the mic.
I was back in college. I have to be honest, a seminar with a bunch of guys around the room, but I'm happy that you called on me. What can I answer?
Yes, I'm thrilled that you're here and that you shared your testimony. You pointed to interagency collaboration failings, in part between DC and DC, but also DC and the federal government. What would you recommend when it comes to more collaboration with court social services? Like, this is the elephant in the room that maybe I shouldn't be so transparent in saying, like, it's just not working the way it should be working. Do you have ideas for ways that we, with our limited power over them, can influence the way things work?
Well, there's a new director of court social services, right? So I haven't had a chance to, meet with her. I've seen her like on meetings, but I think having a frank conversation with her about what services they are currently able to offer, have a chance to talk about what impacts they see on, federal budget, maybe with their agency, whether they're having workforce shortages, what the success rate is of kids who are on probation generally, which we really don't have good data on CSSD more broadly. So just understanding more about her vision of the agency and what her needs are, I think that would be a good place to start. And also just her approach. I mentioned youth development. I just wanted to kind of come back to that a little bit. What we know about youth brain development is teenagers, they have short-term thinking, they engage in risky behavior, peer influence is very strong. And this is even, later development for kids who have experienced adverse childhood experiences. So thinking about this program and how can it build in shorter term positive incentives, because for, a kid telling him, oh yeah, your record's going to go away, maybe that's not that big of a deal for them when they've got, serious issues in their lives, and they've got, and they have, they mostly, want to get off paper, honestly, like adults do. So how do we build in positive incentives for them is something I wanted to, we don't understand exactly how probation works now. Does it incorporate positive incentives or just sanctions? And then thinking about for these high risk and high needs kids who would be involved in this, how do we give them the tools that they need that are developmentally appropriate for them to succeed?
You also talked about that, and I thought it was a great point that there in all of this hasn't been much mention of support for families.
Mhm.
What could that look like?
Well, I think it could start at sort of like a secondary prevention level. When Magdalena testified, she talked about the community school model, which DC has not implemented fully here. It's been very successful in Baltimore, providing those services
That's
to youth
right.
and their families, at an earlier stage. So I think looking at the community school model, how could we build that out and bring that up to scale here in the district would be one way to, hopefully keep address some of these issues, identify some of these challenges families are facing earlier. I think another was, I was horrified to hear what Eduardo said about multi-systemic family. There's therapy, there's also family therapy. And, can we work with these families to look at what some of their issues are? Mama Jo mentioned some, the housing instability issues. If a youth is like, I don't care if I go back to YSC, it's a bed and a meal, that's a problem. So we know from our work with crossover youth, and many of these kids have been involved in the child welfare system, that many families are experiencing substance use and mental health issues. Behavioral health is one of the prime adverse childhood experiences that are in the families of these kids. So are we getting them the services they need to be able, and these youth, want, by and large, want to be home with their moms. They want to be at home with their families, taking care of their younger brothers and sisters, but they want their parents to be healthy and able to participate in that as well. So, I think those are some of the issues that could help. Like I think Eduardo said, some families are frustrated by addressing the behavior of their kids, but can we get them that help earlier? And can we engage with them in a way that is positive and voluntary, rather than feeling like it's like they might lose their kids to the system if it doesn't work out.
Absolutely. Intervention is better than sanctions.
Yes.
Point well taken. I'm gonna end there, but thank you all for your testimony. As I mentioned earlier, we are working on a policy package that we will likely unveil this fall, and it will focus on prevention before a young person encounters the system, rehabilitation while they're in the detention at DYRS, but also reconnection. This piece of, you've done your time, now we are trying to ensure you can thrive back in society. There are clear gaps and loopholes, and you've spoken about that pretty clearly here. And I see this legislation as wanting to address some of that. But what I'm hearing resoundingly through the testimony today, that as drafted, perhaps it doesn't strike the right balance. So as a next step for this committee, we will have a formal round of comments that we will present to the Committee on the Judiciary and the Public Safety. And it is my understanding that that committee will take up this matter early June for their markup, and that markup will include these comments. I will also say transparently that I've shared, as I mentioned, some of my concerns with the bill, and it aligns with what many of you have talked about here. And I have found Councilmember Pinto to take to heart those concerns. So I want you to know that people hear you, and let's hope that the final product reflects your concern. So with that, I'm going to end today's roundtable on DYRS. We will find a time to hear from the director. This is now becoming a pattern where we're getting responses late and/or we're not getting the director, but we will get into a better rhythm because I do think, again, it's important for the director to speak to the fire safety and codes at both facilities within DYRS. The time now is 12:15, and this roundtable of the Committee on Youth Affairs is adjourned. Thank you all.